All right, I'm going to give people a couple minutes to join here. All right, I think I'm going to get started here. So I'd like to welcome everyone to Equitana USA's Equestrian Celebration, our month-long virtual celebration of the horse in lieu of our live event in Lexington, Kentucky. The good news is we will be live from Lexington next year, October 1st through 3rd at the Kentucky Horse Park, so we hope to see you then. In the meantime, we're introducing you to some of our presenters that you'll get to see. Today, we are focusing on Equine Activity Liability Acts with Julie Fershtman. Julie is one of the nation's most experienced equine law practitioners, a lawyer for over 33 years. She is a shareholder with the Michigan law firm of Foster, Swift, Collins, and Smith. She handles a wide variety of disputes in the equine industry involving businesses, partnerships, contracts, personal injury, pretty much anything you can think of. Most recently, she is the author of the award-winning book Equine Law and Horse Sense, published in 2019 by the American Bar Association. And keep in mind, if you have any questions while Julie's giving her presentation, just type them into the chat box and we'll address them once she's done. And with that, I'd like to officially introduce Julie and let you take it away.
Well, hello, Nicole, and hello, everybody who's joining in live or on the replay. My name's Julie Fershtman, and I've got a lot to cover in about 30 minutes, and then we'll get to questions, and there will probably be several. I'd like to also thank Equitana for having me back. I spoke at Equitana in 1996, if you can believe it, or right around that time when they came to Kentucky. And it was a wonderful convention then, and I know they're trying to recreate the same convention yet again. And then they flew me out to California when they ventured out that way back in the late 90s. So it's wonderful to be back. Thank you, and thank you, Nicole. Well, the question is, why are we here? Well, look at this. It's not Christmas time, but check out this ornament. This is a rider unseated from a horse on, of all things, a Christmas ornament. And that's because we know that even in the Christmas ornament world, horses bring risks. People get hurt, people fall off, people get bitten, kicked, knocked down. Things can happen with horses. So let's talk about what we're going to learn today. Here's the plan of action within 30 minutes of what we're going to learn and what we're going to cover. First, the topic being the Equine Activity Liability Acts, we'll start with the good news. The things that people hear about these laws that make them think that they are the greatest thing. And frankly, some of them really are. The second thing is the not so good news. You're going to learn today the exceptions, very briefly, the things in the law, and many of them, on which people can bring a lawsuit. So litigation, injuries, well, injuries are always with us, but disputes, litigation, and problems, they're not gone with these equine liability laws. Why? We'll learn. Finally, let's end on a practical note. What can you do? Depending on the state that you work in, live in, do business in, what can you do to work with these laws? We've got a lot to cover. Let's get started. Only 2 states, by the way, 2 states have no equine activity liability law. Up on the screen, I challenge some of you who don't know the state on the left. That is the state of Maryland. Maryland has currently no equine activity liability law, and California has no law as well. Those of you in either state who are wondering if you're worse off, I'm here to tell you, not necessarily. Why? Well, because California has a very well-developed body of law on assumption of risk. Does that mean that every equine-related injury matter will disappear? Not necessarily, but you at least have a fighting chance, depending on the case, based on the body of law that we call common law as lawyers. There are cases that recognize that being around a horse has certain risks that people assume. All of these cases are very fact specific, but it means that you have something to work with in California. But then you get to Maryland, where I am told that if an injured person is even 1% responsible for his or her injuries, they don't take anything, they don't recover anything. Have I misstated the law in the state of Maryland? Potentially, yes. But those in Maryland who are happy that there's no equine liability law are very excited about the fact that if you are being sued, you can put the blame on the plaintiff to some extent, and they believe cause the case to disappear. Don't hold me on that, but that's what makes some people very happy about that state. The way I view it, though, what we want to avoid is the effort and expense of a lawsuit. We don't want to, if we're being sued, have to spend a fortune in fees. And it seems to me that you may need to do that or threaten to do that in the state of Maryland. More likely, you may have to go to court to prove that the other side is responsible. So both states have their positives and their negatives, but both states do have benefits, people feel, and don't need, at least some say, an equine liability law. Let's check back in another year or two and see if that changes. So here's the good news. Most states with an equine liability law, and of course, keep in mind, every one of the 48 state laws differs, begin with a form where the law states that if a person is injured from an inherent risk, well, they can't recover anything. Let's take a look, for example, I have two states on the screen right now, and it says, let's start with Indiana. Indiana says that subject to Section 2 of this chapter, don't worry, that's the bad news we're going to get to, an equine activity sponsor or equine professional is not liable for, and then it goes on to say, an injury to a participant, death of a participant, resulting from an inherent risk of equine activities. And it goes on to say why a person cannot sue if you are a sponsor or professional and you're not liable. But here's an interesting point you may have spotted in Indiana. Indiana's law gives the benefit to, at least what we see here, people who are sponsors or equine professionals, and the law will define it. Well, what if you're not either of the two? Does the Indiana law benefit you? That's a good question. Take a look at the law very carefully in not only Indiana, if you live there or do business there, but in all the states where you live or do business, and see if you can benefit from these laws, because they do talk about who they apply to. Let's shift gears for just a moment to Ohio. Remember, we're on the good news, and it says, except for a division of the statute, that's the bad news, an equine activity sponsor, equine activity participant, equine professional, veterinarian, farrier, or other person is not liable in damages in a tort or other civil action for harm that an equine activity participant allegedly sustains during the equine activity, and that results from an inherent risk of an equine activity. Looks like Ohio is pretty broad in who might benefit, but you kept hearing the term inherent risks. What's that? Most of the laws will define what it means. So let's take a look at the Kentucky one. This is how Kentucky's Farm Animal Activity Liability Act defines inherent risks. And it says inherent risks of farm animal activities, because it's a farm animal statute, means dangers or conditions which are an integral part of farm animal activities, including, but not limited to, A, the propensity of a farm animal to behave in ways that may result in injury, harm, or death to persons around them. Interesting. Second, the unpredictability of the reaction of a farm animal, which in some states would be equine, to sounds, sudden movement, and unfamiliar objects, persons, or other animals. Very interesting, because that covers a lot of things that can spook a horse. C, certain hazards such as surface and subsurface conditions. D, collisions with other farm animals or objects. And then E, which is not just unique to Kentucky, other states have this in their law. This is another inherent risk, and it says the potential of a participant to act in a negligent manner that may contribute to the participant or contribute to injury to the participant or others, such as failing to maintain control over a farm animal or not acting within his ability. The takeaway from what you've heard on the good news is, if the definition of inherent risk in the state is a broad one, and this is an example of it, And if you stand to benefit from the law because you are an equine activity sponsor, sponsor, professional, or another person, if the law extends to you benefits, this law might offer something helpful to you. But read on, because the laws talk about a little bit more detail to determine if they apply and how you can benefit from them. So let's keep on going. Get ready for the bad news. This is the, well, I'll call it not so good news. We'll try to keep it on a bit of a positive note. And what's the not so good news? Well, there are exceptions in most of these laws. Please remember, again, these laws all differ. Connecticut's law is very different from the Arizona law. All of them seem to have their own unique provisions. Pennsylvania's law is different. I'm going to share with you, as I talk about the exceptions, a general pattern in many of the laws. But please note that what I'm talking about may not be what is in your state law. So let's get rolling. These are the exceptions that people could potentially bring a claim against you on, or you could potentially bring a claim against another on. Here's the list. It's flashing up on the screen, but don't worry, I'm going to go through them one at a time. So let's keep going. I would normally go through the list verbally with you. We've got a time crunch, so let's get going on the list. The first one, faulty tack or equipment exception. This exception is found in many of the laws, and it states basically this. If you provide tack or equipment to another, remember you have to provide it, and that tack or equipment was faulty. Take a look at this bit. This bit is broken, and that faulty tack or equipment is the proximate cause of injury, death, or damage to the equine activity participant. Well, you might be able to get sued under many of the state equine liability laws. So what does it mean in practice? It means this. If you are a riding instructor, if you are taking a friend, coworker, relative on a nice casual ride, and you're providing the horse, it's saddled, it's bridled, take a moment to be sure that the equipment is in good working order. Another example, some of the Western bridles have Chicago screws. You know what they are. Double check to make sure that the screws are securely fastened. Some people will put nail polish in and then turn the screws with the hope that the nail polish keeps the screw more secure. If the girth or cinch may have a problem, the buckles have been having issues, or the ties, the off billets aren't in good shape, take a moment to be sure that the equipment, to the best of your ability, is in good working order. These efforts could potentially save you from a claim under this exception. Here's the next one. This is the exception that is providing, I would think, in fact, I believe, most of the litigation all around the country. And this exception varies all over, but it essentially reads like this. If you provide an equine, but you fail to make reasonable and prudent efforts to determine the ability of the participant to engage safely in the equine activity, and some states go a bit further, you could be responsible. So what does that mean? First, it means you have to provide the equine. Providing the equine, in the classic example I just gave, might be allowing a friend, a coworker, relative to ride your horse. Providing the equine means that you give that horse to the person, hold the horse, for example, while they saddle up, but you provide the equine to another to engage in some sort of an equine activity, as defined in the law. Could be a lesson, could be a ride, it could be a bunch of different things. But the key is that you need to provide the equine. Riding instructors, if you don't have school horses, you're probably going to be fine under this exception because you're not providing anything. If you are merely observing and offering comments and ideas, you didn't provide the equine. This exception only applies when you are giving the use of an equine to somebody else. That tends to be the way the laws go. Let's go to the next exception. I hate this picture. It's so tragic, but it ends well, I'm told. This is the exception that reads as follows. If you own, lease, rent, or are in lawful possession of land or facilities with a dangerous latent condition, what's that? It's a non-obvious condition, for which no conspicuous warning sign is posted, you could be liable. So what's going on here? Well, let's say that the incident that we see here looks like a horse that's got a bridle. Maybe this woman was riding. It may be that this area was on your property. Maybe this area was in an area past your riding arena where you encourage people to take trail rides. And you know that they're going to be riding along a trail or in an open area. But you also know that there's an area that tends to be extremely thick mud that a person's going to sink. Is that a dangerous latent condition of the land? Potentially somebody could say it is. The courts would be the first to make a decision on it. But the argument would be when you let people go out in the back of area of your property and you know that this happens during certain times of the year, it could be that it's best to warn people, not just a verbal warning, hey, watch out for that muddy area along the back of the property, but a sign. This law says a conspicuous, which is to say noticeable warning sign. So this exception applies if you have use of land, ownership of land, a lease of land. There's an area where people are engaging in horse-related activities, but there is an area where the property is not safe. This exception would say you then must warn people. What if there are posts and guy wires? You know what those are. Those are wires that come off the post on an angle. Perhaps nobody would see it unless they run into it. That might be potentially a dangerous latent condition. Some might say, but I can see it. You might say you will only see it if you are galloping and you run into it. What do? Put up a warning sign or maybe mark it off in some way, but do something. That'll avoid liability for this exception. Have there been a lot of cases on this exception? Not many around the country. The failure to make reasonable and prudent efforts exception tends to be where the cases are going. This is the one exception of gross negligence or willful and wanton misconduct. Courts all over the country have different ways of evaluating what that means. Sometimes they will say gross negligence is a cross between negligence, which is failure to do what reasonable people should do, or doing what reasonable people don't do, and intentional wrongdoing. Gross negligence under some state laws then is where you engage in conduct that is pretty egregious and pretty wrong. Willful and wanton misconduct, depending on the state, is often defined in the same way. We're not just talking about an innocent error, but something that could really cause harm. This is another exception under many of the equine activity liability laws. It tends to be either or, gross negligence or willful and wanton. So look at the picture on the right. We have, it looks like maybe an off billet on probably from a saddle, probably from a Western saddle. And it looks to me like the material here was fraying, and it was just a matter of time until the rivet gave out. The person who brought that lawsuit, and it wasn't my case, was probably making an argument that this problem was visible, it was noticeable. People know that horses, as they run, put stress on the cinch girth and the billet straps that hold them. Maybe the argument is, you should have known that this was just ready to break and should have done more. This is the kind of claim somebody could potentially claim is grossly negligent. And then there's willful and wanton misconduct. I love that pony. And the argument there would be, if you know that lady here in the pasture, and she looks like she's ready to kill, is a holy terror, runs after everyone, chases after people with her ears pinned and teeth bared, ready to cause trouble. And she does this repeatedly, and the stable knows that lady is dangerous, lady hurts people, and lady has a well-known history. If the riding instructor says to the student, go pick up lady from the pasture, when it is almost the equivalent of a loaded gun because of her history, we may have an argument on that. It all depends on the facts of the particular matter, but this is the type of claim where there is an elevated risk, like the example I gave where lady had a lengthy history of hurting people and chasing people and biting and kicking. That's the type of setting that could give rise to that. Intentional misconduct, I don't think we need to discuss that. That's an exception to the equine liability laws, but I have yet to see it raised in a case, and there may be reasons for that time does not allow me to get into. Next is negligence. Some of you listening or watching this, listening to or watching this, are wondering, well, don't people have the right to sue for negligence, even with an equine liability law? The answer is no. Under the equine liability laws in many states, negligence is gone as a basis of a claim if the claim is derived from the equine activity. What do I mean by that? I mean that if an equine activity law applies because the person who is hurt is a participant, the person who has the claim against them is another person, an equine professional or an equine activity sponsor, negligence is now replaced by this law. However, what we have is a list of some states that have brought it back. I would like to clarify, I put Michigan there. Michigan's law was amended in 2015. It took out the negligence exception if you are an equine activity sponsor or an equine activity professional. For everybody else, you could potentially be sued for negligence. But to my knowledge, these are the states that still allow some form of a claim to be brought for negligence. The problem I see with that is you have just shared with me, as you've listened, all the things that people can potentially sue for under these laws, and you can protect yourself and you can protect others by checking your equipment, by making sure you have a good understanding of the rider, if it's a horse you're providing for riding, and the horse to make sure they're well matched, for example. You know that you can warn people about conditions of the land where you know they're going to ride that isn't safe, and you know you can make sure you mark it off or post warning signs. You know that you can do all of these different things, but with a negligence exception, lots of different arguments could be made against you. For that reason, I have not been a fan of these laws in many of these states because litigation could potentially still proceed if somebody can make an argument of negligence. Nevertheless, you still have inherent risks that can be used in your defense, that people can't sue for inherent risks. So if you're sued in any of these states, you still have a fighting chance in your defense. Let's move on. What can you do? How can you benefit or try to benefit from these laws? If you are a horse owner, a professional, a stable, an association, let's go take a quick look. First, warning sign requirements. Take a look at the laws where you do business and where you live, and make sure that you comply with the signposting requirements. Why? Because of the 48 equine liability laws around the country now, most of them say that you have to post a warning sign, but most of them say it's the professionals or the equine activity sponsors or both that are required to post the warning signs. So take a look at the law, see if you have to post the signs, see what the signs are required to have. Let's see how they differ here. Look at the slide. Tennessee has something different. I don't believe there's a color requirement, but some states have it. Georgia wants certain language, and Georgia's actually was changed in recent years. If your law is changed, make sure you comply with it. Here's Idaho, and then here's one that looks like it came from, I don't know what state it is. Looks like, oh, it's Illinois on the upper right. But make sure you comply with the law. Take a look, for example, at what the law says the sign is supposed to say. Take a look at the letter size. Many of the laws tell you the signs need to be often 1 inch in height for the lettering. Some of them tell you how many you have to post. Some tell you where. My state, where I'm from, and I'm from Michigan, says to post the warning sign in a noticeable area in close proximity to the equine activity. Actually, it says to simply post the sign in close proximity to the equine activity. So take a look at all of that. Make sure your sign complies. I will tell you that there are signs out there that don't comply. Here are some examples. These are clearly not Equine Activity Liability Act warning signs, although I have to admit I love the attack horse on the left. Ride at your own risk. That is not an Equine Liability Act warning sign. Beware horse bites. Love the sign. I had a horse that would qualify once. That is not a sign. Make sure you separate fact from fiction. Read the laws that apply to you and make sure you comply if you're required to post. But then there's more. Some of these laws, especially the ones with the warning sign requirement, also say that you are required to use certain language in your contracts. What do I mean by that? Take a look at the law because the contract language requirements vary all over the country. Some of them are very detailed. Example, Ohio. Yes, I'm singling out middle United States right now, but Ohio's law says that contracts should have a very lengthy list of inherent risks. Some states, when you go further west, and it's either Idaho or Iowa, it could be Iowa, say that you need to post the warning sign. You need to have contract language with the same thing as your warning sign, just like we see on the bottom of the screen. But then you have to put in your contracts a couple of different things, the warning language and a list of risks. South Carolina has its own requirements, West Virginia. All over the country, the states differ, but keep in mind that you may not need to modify any of your contracts, despite your equine liability law, if the law says that you don't need to. Here's an example on the screen, and it talks about how if there is a written contract, the written contract entered into by an equine professional for providing of professional services, instruction, equipment, or tack, must include the warning notice. Okay, so now you know that if you are an equine professional in this particular state, you would need to include the language at the bottom. But keep an eye out for this, because it may be that you need to include it. What contracts would you need to put this kind of warning or other language in? Take a look at your statute. This one here says if it is a contract for providing professional services, for providing instruction, renting a horse, renting equipment, those would be the contracts that you want to include the warning language. My view, if you're an equine professional and your state has a contract language requirement, put it in all of your contracts, your lease agreements, your boarding contracts, everything. Why not? Let's move on. And I've mentioned, I believe, that there are a couple of states that require not only the posting of a warning sign, but the inclusion of warning language or other language in your contracts. Take a look at your law and make sure that you complied, and that way you are completely in compliance. Liability waivers and releases. Some states, for example, the Arizona equine liability law, also in addition to Arizona, the Virginia statute have said that the entitlement to immunities is in many respects dependent on the person who is your participant, your guest, your visitor, signing off on the waiver. Interesting. Take a look at those state laws if you live or do business there. Again, I referred to Arizona and I referred to Virginia. And I believe there are a few other states that refer to the execution of a waiver being critical to being entitled to immunities. But now let's broaden the concept out, because if you are in a state with one of the 48 states with an equine liability law, can you ask your customer, visitor, guest, even family member, your cousin, to sign a release or waiver of liability? And the answer is, in many states, yes, you can. Even though there's an equine liability law, we're putting that aside right now, you can ask him or her to sign a liability waiver or release, as long as the documents are enforceable in your state. And there are a small number of cases that have said a release can release away even that list of exceptions in the equine liability law, except for a couple of things. You saw the slingshot, the intentional wrongdoing. Most states say you can't release intentional wrongdoing away. You saw the slide about gross negligence, willful and wanton misconduct. Most states say you can't ask a person to release you from that, but not all. There are some states that say, yes, that can be released away. So check to see if your state is one that enforces waivers and releases of liability. Check to see if the language in the waiver release that you want to use is acceptable and legal in your state. Do not necessarily go on a forum online and ask, hey, can you send me your sample release, your document? Because you may be surprised to learn that what works in one state, such as California, may not work in other states, such as Florida. States do seem to have their own individual requirements. Be on top of that. Here are the final points before we call it a day and we get to your questions. First, I'd like you to remember a couple of things. All of these laws differ. Read the laws that are applicable to you. What does that mean? The ones in the states where you live and the states where you do business. Take a look at the laws and determine whether you comply or whether you need to. Next is, remember, some of the laws are changing. If you have information like somebody's form release from years ago, watch out. Kentucky, for example, has a farm animal activity liability law. So does Texas. They weren't always that way. Make sure that the laws are current that you're looking at. And watch, I'm going to share with you a great resource in just a moment. But remember that these laws change. Remember that the laws, in the third bullet point, do not end all liability in the horse industry. Next point, remember that not every horse activity involves an equine liability law. Somebody is driving on the highway, your horse got loose and hit the car. Can you use the equine liability law in your defense against the claim of the injured motorist? And the answer is, based on most of these laws, no. The person driving their car in the middle of the night is not engaging in an equine activity. You can't use the laws for everything. Next is understand your state law's requirements for signposting contract language, for example. Finally, remember, liability insurance remains important. It was important before the laws. It is important now. As you see, people can still bring a claim against you. Great resource I'd like to share with you. I really like this one. If you want to find your state's equine liability law, it's www.animallaw.info. It is from a law school. They are not trying to sell you a thing. It's a bit tough to navigate at first, but it will give you your state's equine liability law if you search well enough. And they update the site just about every year. So you're getting current information. It's a great resource. Well, at this point, I think I need to move on to questions. So I turn to Nicole.
Thank you so much, Julie. Before we get to the pre-submitted questions, I actually have a question for you. I was curious, so in your experience in covering cases like these, how do people go about proving, let's say, they had faulty tack or this horse's behavior was known to be violent? Is this through stable documentation or eyewitness accounts? How do people normally handle that?
The answer is both. Sometimes you'll find eyewitness accounts of horrible things that the horse has done in the past, and sometimes there are documents, but let's face it, in the horse industry, people don't always use documents as they should. So it often comes right down to the history of the horse. I have consulted on or litigated cases where it's really hard to get either one. So experts come out and sometimes inspect the horse. I have mixed feelings about that because just like us, they have their good days and they have their bad days. And I always worry if an expert witness with a fancy resume comes out to a barn to see a horse that is accused of injuring someone and checks out the horse and views the horse's behavior one day, I'm not so sure if the behavior we see maybe a year or two later should be the same as on the day of the incident. So many different circumstances occur. So everything goes into play, which is another reason why I'm a big believer in releases and waivers of liability that are well worded, that comply with your state law, because it gives you something to use in your defense, not to mention a recitation of risks. And of course, think safety.
Definitely, thank you. All right, so to our pre-submitted questions. What happens if there is no Equine Liability Act sign posted, even though the law requires that there should be?
That issue has actually been litigated around the country. It was litigated years ago in the state of Florida, where the professional did not comply with the signposting and or contract language requirements. And the court in that state was left with the question of whether the person can benefit from the law. I don't like the outcome of that case. And the court in that case said, well, if you don't follow these requirements, you really shouldn't benefit from the law. So stable that didn't follow these requirements should not be able to derive any immunities in the law. I don't like that because, especially in the southeastern states of the United States, a lot of the equine liability laws say point blank, very clearly, that if you are required to post the sign, if you are required to include the language in your contracts, and you don't do it, you lose the liability limitations of your law. That's out there for everybody to see, but Florida doesn't have that language. The court just wrote it in. I don't like that very much. There is a case out of my own state. I didn't litigate, but in this case, the stable did have a sign posted. However, on the day of an accident, when somebody was hurt walking through the barn, the sign wasn't there. Why? Because the goat at the stable ate the sign off the wall. And the sign was up there at one point, everybody knows, but on the day of the accident, it was gone, and there was a very happy goat who ate the thing. But the court in that state, in that case, held that was all right, because the stable was in substantial compliance by attempting to post the sign. So as you can tell, these issues get scrutinized a lot. But the view I take is if the law doesn't specify that one thing, like following the law, entitles you to the other thing, which is the liability limited benefit, well, then it's an unfortunate situation, but it shouldn't prevent the law from applying.
Definitely. It's like the dog ate my homework excuse.
It is.
It's funny. All right, the next one. If signposting requirements apply to professionals and equine activity sponsors, can the average non-professional horse owner also post them?
That's a really good question, and people have asked that over the years. I've often taken the view that if your state has a signposting requirement, put up the sign anyway. Even if you are simply a backyard horse owner and you're not a professional, you're not an activity sponsor under the law where your law says you have to post it. Why? Because you're bound to have guests and visitors, and it does seem to send a message that there's a law out there that might affect their recourse if they're injured. I don't mind putting people on notice of that. Some people have also taken the stand of, what if I post that warning sign? And my state law in that warning sign requires that the sign says an equine professional is not liable for the injury to or death of a participant in an equine activity resulting from the inherent risks. The question that people will pose once in a while is, I'm not a professional in the industry, but if I post that sign, have I suggested to people that I am? Could I lose my non-professional status with organizations such as U.S. Equestrian Federation or other groups? The view I take is not necessarily. What you do and how you conduct your activities every day, I don't think can be changed by a warning sign that you post. So the view I take is post the sign even if you're not required to, and post it in a few areas.
Very good. Next question. For people who live and do business in a state with an Equine Activity Liability Act law, so those 48, should they cancel their liability insurance?
In my opinion, absolutely not. Candidly, as many people know, I do a lot of legal work for the insurance industry, and I'm not here as a paid representative of them just to make sure that you spend your money on them. I'm here because I do know that people in the horse industry have been sued, and if they don't have insurance, the question is, how are they going to pay for a lawyer? Litigation is expensive. Personal injury litigation can be especially expensive. And if you don't have insurance, hopefully you have enough money to pay for your lawyer. If your money runs out and the person suing you gets a judgment against you, it's unfortunate and it's not the most pleasant topic, but you do stand to lose everything. If a judgment is entered against you and there isn't any insurance to pay for that judgment, and you don't have the money in the bank, well, that property that you own, that many, many acres of property, might be fair game and might be taken by the person suing you. So I'm not saying this as a scare tactic, I'm saying this as a reality that insurance can save your assets and save the things that you've worked hard for. Insurance can provide you with a lawyer so you don't have to pay one. All of this applies if you have the right insurance. Quick comment on that. If you decide, I want to make a little money today, I'm going to do pony rides to make a few bucks. I'm going to take in a few boarders for some money. I'm going to give a little bit of lesson activity on the side. Watch out, because now you might be engaged in a business. You may need business insurance. So when I say insurance, I say have insurance that's right for what you're doing. If it's a business or even a side business, get the business insurance you need. If it's just a backyard operation, make sure that your homeowner's insurance or farm owner's insurance is what you need.
All right, so the horse community is very much a community and we like to help each other. So lots of people like to share their form releases and boarding contracts in whatever online community they're a part of, whether it's a chat room or a forum. But because all of the states have different laws, what, in regards to the Equine Activity Liability Act, is this something that you'd recommend or should people avoid doing this?
Well, sometimes if you have a lawyer and you want to keep your fee down, because the average lawyer doesn't draft releases for horses, lawyers that do equine law are a lot more familiar with it. But if you want to cut your fee, sometimes you may think it's a good idea to find a couple of examples and show it to your lawyer and then say, here are some ideas that are out there. Use this if you feel it's appropriate to work on something for me. That might be a good thing. But the problems that I see in the horse industry, unfortunately, are when people will go online, they will pull up a document, they have no idea where it came from, they have no idea if it meets the requirements of their particular state, and then they'll find out the hard way that there was a problem. A couple of examples. There have been cases, and I've written about them in my book, about one, for example, a state where the person, it was a business, used a release, but it changed its business name, and the release had the wrong name on it. And so this form document that was used forever was really outdated because it didn't mention the right people being released. That document did not succeed in a legal challenge. I worked on a case where somebody took a form, this is many years ago, right out of a book, a form book for horse contracts. Didn't even check to see if the document complied with their state law, but here's where it got to be a problem. The form in the book said for the person to sign, in exchange for the privilege of riding and working with horses at blank, and it had the name of the farm. It went on to say, I agree to release and indemnify, hold harmless, or something like that. Another blank. Guess what? Nobody filled out the second blank. So we have a release that somebody got from a form book, never checked out by a lawyer, and it didn't even specify who was being sued. So with that in mind, that can be a problem in that the document failed in a legal challenge, and we've got a problem that's easy to recover. Have a lawyer take a look at the document before you put it to use.
Definitely. Last question for you before we let you go. Do equine activity liability acts make waivers and release documents unnecessary?
They do not. As mentioned, I think that you would want to check with your state law just to make sure your state enforces them. But by all means, use waivers and releases, make sure they comply with your state law. And if there is a requirement to add Equine Liability Act language, absolutely do it.
Amazing. Thank you so much, Julie, for taking part in this. I think we all took a lot of good takeaways here. Research, know the laws, and go from there. So we can all hope to see you next year at Equitana USA, October 1st through 3rd at the Kentucky Horse Park. And until then, we'll keep up with the Equitana USA Equestrian Celebration online. Thank you again, Julie.
You're welcome.